Hello, everyone, and welcome to Dorsey and Whitney's Bank Counsel Roundtable, Banks at the U.S. Supreme Court. I'd like to introduce Nick Fleetstra, a partner in Dorsey's Finance and Restructuring Group. Nick?
Thank you, and good afternoon, everyone. I'm Nick Fleetstra, and welcome to the July session of Dorsey and Whitney's Bank Counsel Roundtable, and thank you for joining us. We've planned a 60-minute presentation entitled Banks at the U.S. Supreme Court. Our speakers are Dorsey partners Eric Sherman, Christina Carroll, and Nick Bullard, all of whom I will introduce shortly. But first, a couple of housekeeping details to go over very quickly. Today's program is scheduled for 60 minutes, as I've said, and the materials for the presentation, as well as the attendance form, are available for download through the reminder email that went out to registrants on Monday from events@dorsey.com. As was explained in that email, you should send your completed attendance form to attendance@dorsey.com. Certificates of attendance will be sent to those who return the completed form. In addition, today's PowerPoint deck will also be accessible via a link that we will include in the survey email that we will send out to you tomorrow. Also, please note that we will not have time for Q&A during or after this presentation. If you have a question for our speakers, you're welcome to contact them directly or reach out to your usual Dorsey contact. The speaker's contact information is provided with their bios in the presentation materials. Okay, so with that out of the way, let me introduce today's speakers. Eric Sherman is a partner in the firm's Securities and Financial Services Litigation Practice Group and practices out of our Minneapolis office. He is also co-leader of the firm's Banking and Financial Institutions Industry Group. Eric has more than a decade's experience representing banks, corporate trustees, and other financial services firms in a variety of complex and class action litigation in courts throughout the country. Christina Carroll is a Dorsey partner and trial lawyer focusing on commercial litigation. Christina is based in our Dallas office and is a member of the firm's Banking and Financial Institutions Industry Group. Nick Bullard is an associate in Dorsey's Healthcare Litigation Practice Group and is based here in Minneapolis. Nick first developed a passion for appellate litigation when he clerked for Judge James Loken on the U.S. Court of Appeals for the 8th Circuit. And as part of his appellate practice, Nick is a Supreme Court watcher and writes e-updates for the firm on all the decisions and grants of certiorari from that court. Short bios for our three presenters and their contact information are included at the end of your materials. With that, I will hand things over to Nick Bullard.
Thanks, Nick. Good afternoon, everyone. It's a pleasure to be with you to talk about the Supreme Court. Before diving into the cases and the merits, we want to provide a snapshot of what happened last term and to note four significant trends that have developed. The first trend is that the court continues to decide fewer and fewer decisions. This past term, in the October 2021 term, the court decided just 58 signed opinions. That is in keeping with the last two terms, which the court has also decided fewer than 60 signed opinions. And just to give you 2 points of reference, this is the fewest number of decisions that the Supreme Court has handed down since the Civil War. And just as recently as the 80s, the court was deciding over 150 decisions per term. So really, there's been a gradual decline in decisions for really several decades, and we're at a low point again since the Civil War. I will say, as an aside, despite the court deciding fewer decisions, it seems like the opinions are getting longer and longer. The court had several decisions with 100+ page opinions. So fewer decisions, but longer opinions. The second trend that has emerged recently and was highlighted last term was a decline in unanimity. There was only 29% of the cases of those 58 signed opinions were decided unanimously with all 9 justices or 8 justices if one of the justices didn't participate. This is the lowest rate of unanimity in the last 20 years. And just to give you a benchmark, over the last 12 terms, the rate of unanimity has been 43%. So a pretty significant decline in unanimity. I will note that the decline in unanimity may be related to the decline in decisions. The court is selecting fewer cases, and those tend to be the harder cases, cases which maybe are generating disagreement. And that may also partially explain why there's a lack of unanimity. Next slide, please. The third trend that we saw from the last term is Chief Justice Roberts and Justice Kavanaugh firmly ensconcing themselves in the middle of the court as the swing justices. As you'll see, they were in the majority 95% of the decisions. So almost all of the decisions they were writing or joined the majority, and they were only in the dissent 3 times. And on the flip side of that, the fourth trend is Justice Sotomayor continues to author a number of dissents. She was in the majority just 58% of the decisions, the lowest of any justice. Next slide, please. So final step before we actually dive into decisions now, I wanted to give a little bit of an overview of what we should look forward to from the Supreme Court in this October 22 term. First, it appears that the court will once again not decide a great number of cases. The court has granted certiorari in just 31 cases thus far, and that's actually behind pace even as compared to the last few years, which again, those last few years, the court didn't decide very many cases. So all signs indicate that the Supreme Court likely will not decide more than probably 60 or so cases again this term. Of course, we've also had a changing of the guard. We saw Justice Breyer's retirement and the rise of Justice Jackson, who was sworn in on June 30th. Just a few notes on her. Obviously, it's too early to say what Justice Jackson's jurisprudence will be like, but I will note that she dissented in her very first vote as a justice. This concerned district court had vacated a Biden administration immigration guidance, and the court allowed that ruling to stand pending appeal, and Justice Jackson dissented from that decision and would have stayed the district court's order. So not afraid to make a splash right away. Final note on her is I'll just say that she will have to recuse herself from a few cases. Most notably, there's a case involving the Harvard admissions policy. She was a member of the Harvard Board of Overseers, so has recused herself from that case. But otherwise, she will be a fully participating member of the Supreme Court. With that, Eric, please take it away on some merits cases.
All right, thank you, Nick, and welcome everybody. We're going to kick off our discussion of cases from last term with a trio of cases, all of which have to do with different aspects of the Federal Arbitration Act. Call it an arbitrilogy if you like, or well, call it whatever you want, but in any event, most deposit account agreements and cardholder agreements and others have mandatory arbitration clauses and class action waivers. So application of the FAA is and should be a topic of keen interest for banks, especially on the consumer side. Now, the first case is Morgan v. Sundance, and we actually identified that last year as one of our cert petitions to watch. Since then, the cert was granted, the case was briefed, argued, and decided. And it has to do with when a party delays in moving to compel arbitration. More specifically, it addresses the question whether a party who wants to litigate in court has to demonstrate that it was prejudiced by the other side's delay in making that motion. Slide, please. In Morgan, we have an FLSA collective action regarding overtime wages. And instead of invoking the arbitration clause that was in the employment manual, the employer first moved to dismiss, invoking the first filed rule in light of a similar collective action filed against it elsewhere. Now, the district court in Iowa denies that motion, and the employer files an answer with numerous affirmative defenses. But again, the arbitration clause is not one of those defenses. After that, the parties go to mediation, and when that fails to dispose of the entire case, the employer finally invokes the arbitration clause and moves to compel. And at this point, it's been 8 months since the case was filed. So the Iowa judge denies the motion on grounds of the employer's waiver. And now, in any other context, waiver is the intentional relinquishment or abandonment of a known right. But in the case of a party waiving the right to arbitrate, 9 of the 12 regional US Court of Appeals built in an additional requirement that the party opposing arbitration show that it was prejudiced. And the 8th Circuit was one of those 9 circuits that required a showing of prejudice. So the employer appeals to the 8th Circuit, and the panel splits 2-1, but reverses the district court's finding of prejudice. The employee then petitions for cert, and the Supreme Court grants the petition. and it reverses. Next slide. The court holds that by imposing a prejudice requirement in the arbitration context, the Eighth Circuit is actually putting arbitration agreements on a different footing than all other contracts. And that was what the FAA was passed to forbid. The point of the FAA was to stop judges from discriminating against arbitration in their rulings, not to give it special protections that other contracts don't have. And so Section 6 of the FAA, that's 9 USC Section 6, says that any application under the statute, including one to compel arbitration, is to be made and heard in the manner provided by law for the making and hearing of any other motion. So a motion to compel arbitration is a motion like any other, and it gets no special treatment. Now, in a bit of an interesting twist, the employer may not actually be completely out of luck on remand, because at the end of her opinion, and being a unanimous case, there was only the one opinion, Justice Kagan concedes that waiver might not have really been the right lens for the lower courts to have been looking through, after all. The employer argued that it didn't waive the right to arbitration. That is, it didn't stand up and say, we know we have a right to arbitrate and we agree to forego it. What the employer argued was the lower court should have looked at this case through the lens of forfeiture. And unlike waiver, forfeiture isn't focused on the party's actions. It's more focused really on the party's omissions, as in, is there some firm deadline that the employer missed beyond which it's unable to invoke the arbitration clause? And it turns out that there really is no clear deadline to move to compel arbitration. The FAA doesn't supply one. The federal rules of civil procedure don't supply one. So we'll have to wait and see whether the employer can pull a rabbit out of the hat on remand by persuading the lower courts that the real question is forfeiture and that it didn't forfeit the right to arbitrate by waiting until after that initial mediation and motion to dismiss. Next slide. Our second case is Viking River Cruises, Inc. versus Moriana. So we are going to leave Iowa now and head west out to sunny California. And in previous cases, the High Court has upheld arbitration clauses that prevent an individual claimant from bringing a class action, either in court or in arbitration. And as a result, it's now increasingly hard to find a consumer agreement that doesn't have a clause requiring arbitration on an individual basis. The High Court in the labor context has also held that FLSA plaintiffs who agree to arbitrate can be prevented from bringing a collective action. The Viking River Cruises case is the next in that line and presents the question whether a plaintiff who agrees to arbitrate on an individual basis can be prevented from taking on the mantle of a private attorney general seeking to recover civil penalties for violations that affected other employees, but not the employee plaintiff. Next slide, please. The Private Attorneys General Act, contained in the California Labor Code, allows an employee to sue for civil penalties for violation of many of the code's provisions. Actionable violations include those affecting other current and former employees of the employer. And these cases in California are treated sort of like a key tam case in the False Claims Act context. You'll remember that in a key tam, someone who identifies a False Claims Act violation, called a relator, files a complaint under seal, and the government gets a certain amount of time to review the case and to decide whether it wants to intervene. Even if the government decides not to take over the case, the relator can then proceed with the case in hopes of making a recovery and splitting that recovery with the government. And PAGA in California works in a similar way. The aggrieved employee notifies both the employer and the California state government of violations. If the state declines to investigate within a certain period of time, the employee can then sue, and the employee can join in that action violations that didn't affect the employee at all. And the reward for that aggrieved employee is 25% of $100 per employee per pay period for an initial violation, and $200 per pay period per employee for each subsequent violation. So there's a powerful incentive for the employee to identify as many violations as possible. And that's what we have at issue in Viking River Cruises. Slide, please. So in this case, you had an employee who agreed to forego any class, collective, or PAGA representative action. She claimed her last paycheck came late to her, but with that claim, she joined a bunch of unrelated violations that allegedly affected her former coworkers. The employer moves in California state court to compel arbitration, relying on that arbitration clause, but that motion is denied and the California Court of Appeal affirms. And the reason for that denial is that the California Supreme Court had previously held that pre-dispute agreements to waive representative PAGA claims are void as against public policy. And perhaps unsurprisingly, given Concepcion and Epic and the other cases that have brought us to this point, the Supreme Court reverses. Next slide, please. Now, there were several opinions in this case, and I'm going to focus on the part of the court's decision drafted by Justice Alito that drew 8 votes, because Justice Alito goes down some detours that a number of his colleagues chose not to follow him on. And so what the court holds at its core is that PAGA violates the FAA to the extent that it conditions the enforceability of an agreement to arbitrate upon the plaintiff's ability to add violations that affect other employees, essentially undermining that agreement to arbitration on an individual basis. Under the FAA, parties are supposed to be free to choose what issues they will agree to arbitrate and what issues they will not agree to arbitrate. And when state law conditions the enforceability of an agreement to arbitrate upon the plaintiff being able to add issues to the arbitration that the defendant didn't agree to arbitrate, that violates the FAA. Now, when paired with the structure of PAGA, the court's holding here has some interesting implications for remand. Next slide. First, the court says the employee has to arbitrate the individual PAGA violations, just as it had agreed to do. But that leaves the question, what about the representative PAGA violations? PAGA, however, only confers standing on a plaintiff who has some individual violation to assert. So Alito writes, you can't just come in with a PAGA claim where you weren't injured yourself by some violation. And when the individual violations are taken out of court and sent to arbitration, there's nothing left to support statutory standing under PAGA, and those representative claims have to be dismissed. Now, that little wrinkle draws an interesting concurrence from Justice Kagan. And Justice Kagan picks up on a part of Alito's opinion where he acknowledges that it doesn't violate the FAA for California law to say that you cannot require an employee to give an employer a wholesale waiver of PAGA claims. The FAA doesn't go that far. And Kagan says to California, hey, look at this statute. This is a problem you can fix. You can you can legislate around this and find a way in which these representative PAGA claims don't get dismissed for lack of statutory standing. So in the future, look out for California to pick up on Justice Kagan's concurrence and perhaps to do just that. Now, you'll also remember I said it was an 8-1 decision as far as the judgment goes. The lone dissent comes from Justice Thomas, who, unlike any other members of the court, doesn't believe that the FAA binds state courts at all. So as far as the FAA is concerned, he would have allowed both the individual and the representative PAGA claims to proceed in state court. But as of now, Justice Thomas is the only justice to express that view. Now we're going to move on to Badgerow versus Walters. One of the things about the FAA that's always been a bit awkward is that although it's a federal statute, and although it authorizes the bringing of various petitions and applications and motions in court, it does not contain any grant of federal jurisdiction. So when you bring a petition to compel arbitration, the courts previously ruled that you have to look through the petition itself to whatever the underlying controversy is that you want to arbitrate, and to see if that underlying controversy could have been brought as a case in federal court, either because it involves a federal claim under Section 1331, or under Section 1332 because there's diversity of citizenship between the parties and at least $75,000 in dispute. Now, it's been an open question whether that look-through approach to federal subject matter jurisdiction is valid just for petitions to compel arbitration, or whether it also applies to other sorts of requests authorized under the FAA, like ones to appoint an arbitrator, to compel witnesses to give evidence, or to confirm or vacate the resulting award. On that point, the circuits have been split. Slide, please. In Badgerow, the court addresses that split, and in an 8-to-1 decision delivered by Justice Kagan, takes a fairly rigid textual approach to the question. And Justice Kagan says, no, the look-through rule applies only under Section 4 of the FAA. And that's the section that authorizes petitions to compel arbitration. And that's because of some peculiar language in Section 4 that talks about how a party aggrieved by the failure to arbitrate may petition any U.S. district court which, save for such agreement, would have jurisdiction. That's where the look-through approach comes from. And that language is unique to Section 4. If your petition is under any other section, the court says the question of federal jurisdiction rises or falls on the face of the petition itself. So that raises some thorny issues. If you've got an application to confirm an arbitration award and the parties are diverse and the award is more than $75,000, it seems clear that there's diversity jurisdiction to bring that application in federal court. But what if you're a plaintiff and the arbitrator zeroed out your $10 million claim and you were moving to vacate and get another bite at the apple? What's that worth as far as the amount in controversy analysis? I'm not sure, and the opinion doesn't say. But the likely result of all this is, and the court acknowledges this, more of these applications to confirm or vacate or to compel witnesses or to do all the other things that the FAA authorizes other than compel arbitration are going to be ending up in state court, absent some legislative change. And the friction that this new reality is going to create really becomes the central theme of Justice Breyer's dissent. He takes a more holistic and less compartmentalized view of the FAA and says, yes, well, maybe the look-through approach is only mentioned in Section 4 alongside petitions to compel arbitration, but that's because the petition to compel is the initial step in a comprehensive process that proceeds on through the other sections on appointment of arbitrators and marshaling of evidence, and finally ends with confirmation or vacation of the resulting award. And so to Breyer, it makes perfect sense that you would take a single jurisdictional approach to open up all the relief that the FAA has to offer. But unfortunately, Justice Breyer did not persuade any of his colleagues to follow that approach in this case. And so the problems that are to be encountered are left up to Congress to fix if it so chooses. And now over to Nick Bullard, who's going to discuss an administrative law case from last term.
Thanks, Eric. And this will be the final decision that we're going to talk about from last term before we turn to the upcoming term. So this West Virginia versus EPA decision, this is a very important decision regarding the power of federal regulators in heavily regulated industries like banking. And while the case arises in the context of environmental regulation, its impact will extend far beyond just the environmental world. So let me set the stage by providing a little bit of background. This case arises under the Clean Air Act. In 2015, the Obama administration's EPA issued what's called the Clean Power Plan. The Clean Power Plan, in simple terms, required coal-fired electric generators to transition away from coal to other renewable energies. The EPA relied on what was called in the legislative history an obscure, never used section of the law, a very infrequently used section of the Clean Air Act in order to enact the Clean Power Plan. In 2016, when the Trump administration came in, they stayed I skipped a step, excuse me. The Supreme Court then stays the Clean Power Plan. The Trump administration then comes in 2019, repeals the Clean Power Plan and issues a new rule in its place. And then the DC Circuit vacates both the Clean Power Plan and the repeal of the old rule and the new rule as well. So the court is faced with the issue, did Congress authorize the EPA to adopt the Clean Power Plan? And the majority of the court says no. And the court goes through sort of standard statutory construction, and that's really not relevant for purposes of our presentation today. What is relevant is that the court announces for the first time, recognizes for the first time, what's known as the major questions doctrine. Now, it's easy to state the major questions doctrine. Basically, before a federal agency is going to issue a rule that will have vast economic and political impact, it has to point to clear congressional authorization for that action. While it may be easy to state the rule, you can see it's very hard to apply the rule in practice. How vast does the decision have to be? What counts as politically significant? There's a lot of room for ambiguity. Next slide, please. This now formally recognized major questions doctrine, I think it's safe to say, will have a major impact in litigation in the future. As Congress, there continues to be gridlock in Congress, federal regulators, I think, will continue to look for new and creative ways to regulate industry. And I think litigants will now have a new powerful weapon in their arsenal, the major question doctrine, to challenge whether those regulators really had the authority from Congress to take the action that they did. Two particular areas stood out to me as potentially where this potentially could come up. The first is the SEC's climate disclosure rule. As I'm sure many people on the call know, the SEC has proposed a new rule that, if adopted, would require public companies to provide detailed reporting of climate-related risks, emissions, and transition plans. I suspect the litigants will be challenging that climate disclosure rule when one of their arguments will be this major questions doctrine, saying the SEC has to point to clear congressional authorization for issuing this new rule. Another potential area is the regulation of cryptocurrency. I know there's been a lot of rumblings about federal agencies beginning to regulate in the cryptocurrency space. Again, I expect litigants will use the major questions doctrine to challenge whether federal regulators have that authority. And I would just note that the three of the justices dissented from the West Virginia EPA in a decision written by Justice Kagan. And Justice Kagan, I think, quite persuasively pointed out that this doctrine is going to be very hard for lower courts to apply. Again, how major does the decision have to be? How much impact does the rule have to have? And I think we're going to see in the coming years and decades a lot of litigation over how this rule applies. And we should expect this doctrine to rear its head again in the near future. So with that concludes our review of the decisions from last term. Now we're going to turn our attention to the decisions coming up in this term, 2022. And with that, I'll turn it over to Christina.
Thanks, Nick. Let's look at Bittner versus United States. This is a case out of the Eastern District of Texas. It went up to the Fifth Circuit. And essentially, the petitioner, he was born in Romania. He spent 9 years in the US, at which point he was naturalized. And then he returned back to Romania after 1990 for 20 years. Now, because he was a dual citizen, US and Romania citizenship, he was still supposed to file certain tax forms while he was abroad, which he claims he didn't know until he returned to the US in 2011. So upon his return, he filed taxes from 1996 to 2011. Because of the statute of limitations, only 5 years or so were actually at issue in terms of penalties. So he amended those reports. And on each of those reports, it was for the years 2007 to 2011. On each of those reports, he disclosed 25 or more different bank accounts that he had in offshore or mostly Romanian bank accounts. Now, the Bank Secrecy Act requires that any person who has control of a foreign account with $10,000 or more is supposed to file a report of foreign bank and financial accounts, or called an FBAR for short. And you're supposed to file June 30th of every year for the year prior. The question here is, does a violation occur per form or per account? And we'll get into that in a minute, but know that a non-willful violation of this rule comes with a max $10,000 fine. Let's go to the next slide. And you'll see that in the Eastern District of Texas, they said that this violation is per form, but the Fifth Circuit reversed. And here we get into the circuit split. The Ninth Circuit and the Eastern District of Texas agree. So they say because this violation is per form, that Bittner would only be subject to a $50,000 fine, having filed these 5 years late. The Fifth Circuit says the violation is per account. Now, when I mentioned that there were 25 plus accounts, bank accounts that were disclosed on these 5 forms across these 5 years, that amounts to 272 violations for $2.72 million in fines. And what else is tricky is that the IRS says both. So in the Ninth Circuit, they'll say it's performed, and in the Fifth Circuit, they'll go after a violator for per count violations. And really, the arguments seem to focus on the duty under the regulation. So the Ninth Circuit and the Eastern District, Texas, say that the regulations really only require one form to be filed each year. So the violation is of one form. Whereas the Fifth Circuit says that the regulation is meant to require individuals to disclose each foreign bank account. So the violation is failure to disclose each foreign bank account. Some notable takeaways, the average FBAR actually discloses about 10 accounts. And in a year where there were 900,000 FBARs, you're talking 9.5 million accounts. So in terms of violations, that could get pretty costly or pretty handsome for the US, I suppose. There are 40 million plus foreign-born US residents. And again, in this situation, Bittner was actually a Romanian citizen who happened to have dual citizenship with the US. So of course, this is an ongoing issue, and keep an eye out, but also consider whether we should be counseling clients on the disclosure of foreign accounts. All right, Eric, I think I'm kicking it back to you.
All right, thank you, Christina. We're going to turn to Mallory versus Norfolk Southern Railway Company. There have been a number of significant personal jurisdiction cases to come out of the court in the past several years, and this is going to be another one. The question this time around is this: can a state, by requiring a foreign corporation to register to do business in the state, extract consent to general jurisdiction over the foreign corporation in that state's courts? Now, because of the National Bank Act, this may not be a primary concern for our friends at national banks, but it could be an issue for separately organized affiliates that register with state secretaries of state, and it's a concern for state banks, I think, with interstate operations. Mallory itself, however, is a railroad FILA case. And Mallory lives in Virginia, and he works for a Virginia Railroad Corporation based in Virginia. And he does his work in Virginia and Ohio, and that's where he says he was exposed to carcinogens. He doesn't sue in any of those states, however. He sues in Pennsylvania. And the railroad moves to dismiss for want of personal jurisdiction. That motion is granted, and 2 levels of the Pennsylvania appeals courts affirm that dismissal based upon the prior cases that have brought this to this point. Those, slide please. Those Pennsylvania courts say that under the Supreme Court's decisions in Goodyear and Daimler, it is a due process violation for a state to exercise general personal jurisdiction over a corporation absent affiliations with the state that are, quote, so continuous and systematic as to render the corporation essentially at home there, end quote. And that has, since a few years ago, been the standard for general personal jurisdiction. And it generally limits that general jurisdiction to the state of incorporation, and if different, also the state of principal place of business. And if a state tries to force a foreign corporation to consent to general jurisdiction by withholding the privilege of doing business in that state, well, the court says that's coercion, and that coercion is a due process violation. Slide. Now, the railroad hasn't filed its merits brief yet, but we can expect it largely to hew to the path that the lower courts, I think, have drawn, because I think that's probably what was argued below. Mallory's brief, however, is on file, and he says a few things in response to all this. Mallory looks back and he says that state statutes requiring foreign corporations to consent to jurisdiction were upheld both before and after the adoption of the 14th Amendment and its due process clause binding on the states. International Shoe and its progeny, meanwhile, he says was not a rollback of having states require a consent to jurisdiction of this sort, but rather an expansion of jurisdiction over non-consenting corporations based upon their contacts with a forum state. And finally, Mallory says that requiring corporations to give up what is really a waivable procedural right, because in an individual case, a defendant can always consent to personal jurisdiction, just simply doesn't rise to the level of a due process violation. Norfolk is going to file its brief on August 26 if the current schedule holds, and the case is to be argued on October 11th. So we'll keep our eye on that. And now back to Nick Bullard.
Sarah. We're going to discuss now the MoneyGram cases. So these cases involve the issue of unclaimed property, that is property or accounts within financial institutions or companies in which there's been no activity regarding the property or the account for a year or more. This is the first time I believe the Supreme Court has weighed in on the issue of unclaimed property in about 50 years. And the specific issue is what to do with uncashed and unclaimed official checks issued by MoneyGram and sold across the country. There are, of course, state and federal sheet laws governing reversion of unclaimed property back to the states. MoneyGram's practice to this point has been to return all of these unclaimed checks, or the vast majority of them, to Delaware, where it's incorporated. And there's a group of states, about 30 states, that are arguing that those checks should actually be returned to the states where they were purchased, not returned to Delaware, where MoneyGram is incorporated. Delaware filed an action directly in the Supreme Court, asking the court to resolve this question. And as a reminder, there is a provision in the US Constitution that gives the Supreme Court original jurisdiction over disputes between the states. And that's the constitutional provision that Delaware invoked in order to file this dispute right in the Supreme Court. The Supreme Court, as it often does in these type of disputes, selected a special master to rule on the issue as a preliminary matter. And the special master did recommend a judgment against Delaware and in favor of those other 30 states, saying the unclaimed MoneyGram checks should return to the states where the MoneyGram checks were purchased. Next slide, please. So let's zero in a little bit on the actual precise legal issue in the case. The key federal statute at issue is the Disposition of Abandoned Money Orders and Travelers' Check Act. The act governs money orders or similar instruments. Those terms are undefined, and they're the key to the case. If the MoneyGram checks are money orders or they're similar instruments, then they would not be escheatable to the states where they were purchased. But if they are not money orders or similar instruments, then federal common law applies, and the checks would escheat to Delaware, the vast majority of them. So this is sort of the central issue in the case is, are these MoneyGram checks money orders or similar instruments within the meaning of the Abandoned Money Orders and Travelers' Check Act? As I mentioned, the special master resolved this question in favor of the challenging states and against Delaware. The special master conducted a really thorough statutory construction. They applied tools of statutory construction, looked at legislative history, consulted dictionaries, and ultimately concluded that the unclaimed checks should revert to the states where the checks were purchased, not to Delaware where MoneyGram is incorporated. Delaware has now objected to that finding, and that is where the Supreme Court will come in. The Supreme Court has set this case for argument in October of this year, and it will weigh in on whether the special master got it right or not. I will note that the American Bankers Association filed an amicus brief in this case. The American Bankers Association didn't take a view on which set of states had it right, Delaware versus these challenging states. Instead, it urged clear rules to minimize banks' penalties, burdens, and potential liabilities from handling this unclaimed property. So again, we will look for this case set for argument in October, with hopefully a decision in a few months after that. With that, we're going to shift our focus now to petitions for certiorari that are actually pending currently before the Supreme Court. Christina?
Thank you. So one of the cases is Turkey AS versus United States. If I butcher the name, I apologize out there to those who speak more fluently than I do. This concerns the Foreign Sovereign Immunities Act, which provides immunity from civil liability for foreign sovereigns, except for when there's commercial activity. Commercial activity can be activity within the U.S., activity connected to the U.S., or that occurs outside of it, has effects within the U.S. Now, Halk Bank is majority owned by Turkey, so it qualifies as a foreign state under the Sovereign Immunity Act. And the U.S. found that this bank participated in a scheme to divert funds to circumvent sanctions that the U.S. had against Iran. So the U.S. prosecuted 3 bank executives and went after the bank itself. The bank argued immunity. The Southern District of New York, said that there was no immunity for criminal acts, and even if there were, then the commercial activity exception would apply. The Second Circuit agreed. So the issue is, can the U.S. indict and sentence a foreign sovereign? The Second, 10th, and D.C. circuits all say yes, and they focus on a different area of law, 18 U.S.C. 3231, which says that the U.S. can prosecute all offenses against the laws of the United States. The Sixth Circuit says no. And it seems that these circuits are kind of flipping how they view the Sovereign Immunities Act, at what point they apply it. For instance, the Sixth Circuit says we look at the Sovereign Immunities Act first. It is the only way that the U.S. is granted jurisdiction against a foreign sovereign, and the only jurisdiction is civil, period. The Second, 10th, and D.C. circuits say that the Sovereign Immunities Act only applies to civil cases, and if it's not a civil case, then no issue, we're going to come after you. So the reason this is important is because of RICO implications. For years, courts have held that the U.S. cannot assert RICO claims or prosecute RICO claims against foreign sovereigns. And if we open up this field of criminal liability for foreign sovereigns, then of course that would include RICO violations as well, which would implicate foreign policy. As you can imagine, if the U.S. starts to prosecute foreign sovereigns for criminal liability, then the concern, or one of the arguments at least, is that foreign sovereigns, foreign countries do the same for U.S. citizens. Let's go to the next slide. This is a second case concerning the Sovereign Immunities Act, NSO Group Technologies Limited versus WhatsApp. Now, traditionally, the Sovereign Immunities Act only applies to foreign states, not individuals, and common law filled the gap. There's something called conduct-based immunity that applies to foreign individuals, foreign officials, and agents, including private agents. There's even a U.S. Supreme Court case already out there, Samantha versus Youssef, that says if the Foreign Sovereign Immunities Act doesn't apply, then common law fills the gap. In this case, NSO Group Technologies is an Israeli company that deals in highly regulated technology to combat terrorism and crimes against children. And it has this application called Pegasus. The application was used to access 1,400 WhatsApp accounts to investigate what they claimed was an Islamic State terrorist attack that was being planned through using WhatsApp. WhatsApp notified those 1,400 accounts that were accessed, killed that investigation, and then WhatsApp sued under Computer Fraud and Abuse Act and some other laws. The Northern District of Texas said that the NSO is not a government entity. The NSO is a government entity because there was no argument to the contrary, but there's no immunity because any judgment wouldn't actually bind the Israeli government. The Ninth Circuit also found no immunity, but it said that there's no immunity if the NSO doesn't meet the definition of a foreign state under the Sovereign Immunities Act. The Ninth Circuit also found that the Sovereign Immunities Act completely displaces common law instead of the two, filling this field together. So the question is whether a private entity can seek common law sovereign immunity. The Fourth DC Circuit say yes, and the Ninth Circuit says no. The Ninth Circuit again says that the Sovereign Immunities Act is the only law that applies to entities. There's no common law that applies. And once again, the concern here is foreign policy issues, one being reciprocity. What will happen if we apply this rule, and then how will the countries apply it back to us? Thank you, Nick.
Thanks, Christina. And just one note about that last case that Christina was talking about, the Supreme Court did ask for the views of the Solicitor General. They asked the Solicitor General to weigh in on whether the court should grant cert. That's often a sign that the court is seriously considering granting cert. And Christina, correct me if I'm wrong, but the case you talked about before that, I believe the Solicitor General filed a brief in that case as well. So these are two cases that the Supreme Court is really seriously thinking about granting cert in. With that, I'm going to talk now about the Kinney versus HSBC Bank case. This is a bankruptcy case. So first, just a little bit of background here. So the petitioner was a Chapter 13 debtor. She defaulted. She was an individual. She defaulted on her bankruptcy plan by failing to make her monthly mortgage payments. The mortgage holder, the bank, moved to dismiss the case due to Ms. Kinney's material default of the bankruptcy plan. After that had happened, after the plan term had ended, and after the bank had moved to dismiss, Kinney then submitted the missing mortgage payments. The bankruptcy court, however, concluded that Ms. Kinney was not eligible for a discharge because she didn't submit all the required payments within the plan's terms. And the bankruptcy court ultimately dismissed the bankruptcy. There is some precedent from the Third Circuit and a few other lower courts suggesting that Chapter 13 debtor can submit the final payments on a bankruptcy plan even after the end of the plan term. The 10th Circuit came to the opposite conclusion. It concluded the debtor cannot make up payments after the plan period ended. Ms. Kinney has now petitioned for certiorari at the Supreme Court, and the issue presented is whether a Chapter 13 debtor, like Ms. Kinney, can obtain a discharge if she defaults, but then makes up the missed payments after the plan period is ended. Like the cases I was just talking about, that Christina just covered, the Supreme Court did ask the Solicitor General to provide her views on whether the Supreme Court should take this case up. As of today, I checked the docket earlier today, and it looks like the Solicitor General has not yet filed a brief and expressed a view on whether the Supreme Court should, in fact, weigh in. But again, as I mentioned, this is a sign that the Supreme Court is seriously considering taking up this Kinney case, which would decide an important issue in federal bankruptcy law. Next slide, please. The final petition that we have our eye on is this Buffington versus McDonough case. Now, this case arises, it's a veteran affairs case. It involves the interpretation of a veteran benefit statute. And ultimately, the VA took an unfavorable view of the statute as far as veterans are concerned, and the Federal Circuit ultimately deferred to the VA's interpretation, relying on the Chevron doctrine. Of course, the Chevron doctrine is a doctrine that says ambiguous statutes, the courts should generally defer to agency interpretation of ambiguous statutes. As court watchers may be aware, several Supreme Court justices have been indicating that they have interest in revisiting Chevron deference. The Supreme Court has pared back agency deference on a number of fronts. And actually, notably, this past term, Supreme Court in multiple cases involving agency interpretation didn't cite Chevron or its progeny at all. So for example, in that West Virginia versus EPA case, even though all the parties were talking about Chevron and asking for deference to the EPA's Clean Power Plan, the Supreme Court didn't even acknowledge Chevron at all. So that's just one sign, but the Supreme Court has given other signs that it may be interested in overruling, or at least considering again the Chevron deference doctrine. And this case, this Buffington versus McDonough, although it arises in the veteran benefit statute, the second question presented is whether Chevron should be overruled. This case has generated a lot of interest given the stakes. There are many amici have filed briefs urging the court to overrule Chevron. And this case comes at an interesting time, given that the Supreme Court has shown a willingness to push back on federal regulators. Again, think of the EPA case we talked about earlier. The Supreme Court was willing to invoke a new doctrine, the major question doctrine, to push back on federal regulators. And again, this Buffington case may give the court an opportunity to do so again. And second, the Supreme Court has also shown a willingness to overturn precedent. I'm thinking here of the Dobbs decision from last term. So Buffington presents the court an opportunity to both push back on federal regulatories and potentially overrule or reconsider a major precedent in Chevron. With that, that concludes the material we had prepared. It was a pleasure to be with all of you, and given that we have a little bit of time, I don't know if we can entertain questions or if we just need to conclude at this time.
I would like to add one thing that I forgot to point out on the NSO case. NSO, this is the NSO versus WhatsApp, and the argument was that NSO was acting on behalf of the Israeli government. And so when I said that the NSO was considered a government agency, it's because WhatsApp didn't argue to the contrary. And I think that's relevant for banks because I'm sure we can all imagine a situation where a bank is considered is acting on behalf of a foreign state where this might become an issue. So I wanted to make that connection plain so that you can see the relevance.
Okay, well, thank you, Eric, Christina, and Nick, and thank you, audience, for your attendance and attention. Please remember to sign in on the attendance sheet and return it to attendance@dorsey.com. And remember, if you have questions for our speakers, you'll find their contact information in the presentation materials, or you can reach out to your usual Dorsey relationship contact. Our next meeting of the Bank Counsel Roundtable will be in September. Look out for your invitation, and we will see you then.